this was against tribal law. I think the faces in the audience are suggesting that this sounds a little bit strange in terms of the reasoning, but this was the court's reasoning. Go to the next slide, please. So we'll take the facts of this case and apply them to the criteria here in terms of the four that we established. There are evidently two different governance traditions here. We have federal law, represented of course by the Supreme Court of the US on the one hand, and then we have tribal law, so Scottish tribal law on the other hand. Just for use of the slides here, I'm rolling criterion 1 and criterion 2 together. We can see here two different governance traditions, and that each governance tradition is capable of giving people pro tanto moral obligations. So I've run these together here, but just to flag that up. The conflicting obligations, on the one hand we have don't resist arrest by tribal police officers, don't assault tribal police officers. This is the law within this jurisdiction, and arguably should apply to everyone within the tribe's territory, within the reservation. And we have the conflict, we have the negation of this. The federal law held on appeal to the SCOTUS says no such obligation. Tribal law lacks jurisdiction over non-Indians, and therefore Oliphant had immunity to arrest from tribal officers. The final criterion, is there sufficiently legitimate body to adjudicate? No. The Supreme Court, arguably a court of the colonizer, Suquamish Court, never had the opportunity to act. Interestingly here, the Suquamish Court was prevented from exercising its authority. So if we take the hypothetical, had they not recognised the writ of habeas corpus, then they would have been acting illegitimately. So if they had not released Oliphant after his dust up, then they would have been acting illegitimately. So I'll pass back to you.
Sure. So just to run through this again, these, you can see how those criteria hopefully map on to that example. And then what I'm going to do now is I'm just going to take you through each step to provide a little bit more detail on exactly what we mean. So if you just hold that example in your heads, we'll go through it and then we'll give you another one later. So to start with, legal obligations. Now, just to remind you, this is obviously a non-positivistic account of legal obligations. The nature of legal obligations is in itself contested. There are no positivists I know that would agree with us about this. So you just have to take it from us that this is what the other side of the coin looks like. So a legal obligation for a non-positivist is a kind of pro tanto moral obligation, right? So it's a subset of our moral obligations. A moral obligation is a conclusive reason or set of reasons for behaving in a particular way. And reasons here, we don't mean, as Jen mentioned before, motivations or beliefs about reasons. We mean reasons as a kind of normative fact. So the reasons that actually apply to you or genuinely apply to you, no matter what you might believe about it, right? Pro tanto in this context means conclusive for the time being, so it can be overridden by more weighty moral considerations. So the idea is that if a genuine legal system exists, it gives you reasons to comply with the obligations that arise from it that might be overridden in particular circumstances if other weightier considerations come to bear. And legal obligations, we say, are a distinct kind of pro tanto moral obligation because they arise in part due to the existence of legal practice. So remember the Parliament of the UK example? You might have reasons to follow obligations set out in legislative texts for reasons of democracy, but you would not have those obligations were it not for the existence of those legislative texts. So an analogy here might help. In the same way that I have pro tanto obligations to keep my promises, in part because of social practices of promising, right? In the same way, I have pro tanto obligations of a legal nature because of our legal practices. Okay, so they're, legal obligations are a thick concept. So there's part practice, part moral normativity. what does it look like when obligations conflict? So we need to, again, be very careful here to distinguish the fact of conflict from a belief in conflict. So this relates to what it looks like when legal obligations conflict as a matter of fact. So on the top half of this little diagram, you have weak or seeming conflict. And that's when the conflict is only apparent. It can be resolved by appeal to other moral reasons or by sharpening our understanding of the obligations that appear to be in conflict with each other. On the bottom, you have strong or actual conflict, where two or more obligations exist, and there is no reason to choose to comply with one rather than the other, so that the answer of what to do when faced with that couple or more of conflicting obligations is indeterminate. So the top half is only is a resolvable conflict, the bottom half is irresolvable, and then in addition to that, a conflict might be either trivial or not trivial, and that's more of a sliding scale. And there might be many reasons why we might think that even a strong conflict is a trivial one, because maybe the conflict of obligations doesn't really matter, because the obligations aren't really all that important. Conversely, we might have a very important weak conflict, a conflict that could be resolved, but we should really care about the particular situation that that conflict gives rise to. Okay? We are largely concerned with non-trivial conflicts in this paper, although we make room for the possibility that there could be trivial conflicts as well. Okay. When you move from the level of fact about the conflict of moral obligations to the level of belief, this is where we start departing from other non-positivists. So we agree with them that beliefs about the conflict of obligations may or may not correspond to the fact of the matter. So we do agree that we should distinguish between sort of the object level of moral fact and the subject level of beliefs about moral fact. However, traditionally, non-positivists don't place much store in beliefs about moral conflict or beliefs about morality in general as such, right? So generally speaking, they're only interested in beliefs about morality to the extent that they happen to reflect the fact of the matter, right? This is actually a really important point, because this is one reason for people like George Letsus rejecting the possibility of legal pluralism, right? Because they say, well, what actually matters is the real existence or non-existence of conflict, not the belief in conflict, right? We accept that there might be beliefs in conflict, but as far as the law is concerned, all that matters is reality. So we don't care about we don't care about legal pluralism. It only happens at the level of belief. So the argument goes. We argue, on the other hand, that at least in some non-trivial conflicts, some beliefs about conflicting obligations have their own moral importance as beliefs, right? So, and we also argue that these sorts of beliefs almost always arise in post-colonial situations, such as the Oliphant case, right? And the relevant beliefs are the beliefs held by dominated groups. In many ways, the fourth criteria that we put forward for legal pluralism is the most important. And this is because political legitimacy, concerns with political legitimacy, are what makes beliefs about legal conflict important in this way. So just to set out the nature of the problem in general, political legitimacy is about the justifiability of governance or the use of political power, right? So we suggest that governance requires justification because it elevates some people rather than others to positions of power and enables those people to use collective force of their political community as a means to coerce others. This creates problems of equality and autonomy. It presumptively violates those values, and it's actually quite difficult for a governance tradition to deal with this problem. in order to square the circle, they have to govern in such a way as actually reinforces equality and autonomy. And that requires certain institutional features, but it also requires certain substantive legal principles to be put into practice. All of this is to say, political legitimacy is morally important because of its implications for equality and autonomy, and that even in ordinary circumstances, it's actually quite a high threshold to meet. Okay.
Yes, so we would submit here that in a post-colonial situation, it is especially difficult for a state to meet this standard. So it's difficult in the first place, but it's particularly difficult in a post-colonial situation, especially in terms of its dealings with colonised peoples. And we just list the steps here. First and foremost, we would say there's a duty not to subjugate or dominate other political communities. Once this duty has been violated, the next best thing is to afford particular respect to any remaining traditions of self-governance on behalf of these political communities. Now, the best way of doing this would be to cease any dominating activity and to facilitate renewed self-governance, or to allow self-governance that was already occurring. In the event that that is not possible or not performed upon, then the next best thing, you can see how this is all the way down, the next best thing is to accord particular weight to that community's shared beliefs about their own legal and political obligations. And this then enjoins the dominating community to refrain from proclaiming upon how apparent conflicts between their governance tradition and the dominated group's governance tradition should be resolved. In this sense, you can see quite clearly how the position of any Supreme Court, for example, as ultimate arbiter could be called into question. Why is this important? Well, it's important because it's happening. So we mentioned earlier on that we're looking at legal practice, and this is happening. You can observe it in a number of different jurisdictions. We've chosen today to focus on the US. When an illegitimate decision is made, so when you have a decision by a body that lacks legitimacy, we can say that a moral wrong occurs. And not only is there a moral wrong, the wrongdoer further undermines that legitimacy and causes a degree of ethical harm to themselves. The treatment of indigenous peoples oftentimes is illegitimate, and this in circumstances that we would identify in our moral reading as being legally plural. In this sense, what's the way out of this bind? Well, one solution arguably could be one of dialogue. The circumstances of legal pluralism that fit within this model could be solved by dialogue, and this is arguably because the circumstances arise where the problem isn't just to fall back on what we would recognise as being a weak or classically pluralist solution, which is basically, this is causing us a problem, this is a recalcitrant social reality, to quote, I'm pretty sure it's Sally Mary, and so we're just going to, we don't care enough about it, and we're going to let you sort it out on your own. This is something that we saw in British India, happened a lot. And this isn't the type of situation that we're talking about, because the assumption shouldn't always be that where there is accommodation, that is necessarily the right answer. So I'm going to provide another example to supplement the one we gave earlier, the one of Oliphant. So this is just a quick reminder of the criteria, the 4 criteria again, before we talk about Devil's Tower. Devil's Tower, national monument, the very first national monument in the USA, in the state of Wyoming, made a national monument in 1906 and controlled by the National Park Service. Interesting history, Devil's Tower. It really wasn't until the 19th century that it got a huge amount of attention from Westerners, from Americans, so to speak. But it became very quickly a premier climbing resort The first climb was in 1893, but it became a site of real recreational climbing in 1977. Today there are over 200 climbing routes, and there are 600 metal bolts and several hundred metal pigeons embedded in its face. It hosts several thousand climbers a year. So we take this set of information on the one hand. On the other hand, we look at its importance to Indian tribes in the area. So the tribes, the Arapaho, the Cheyenne, Crow, Kiowa, Lakota, and Shoshone. And these tribes, for them the site was primary and significant to their religion. If you're interested, I'm conscious of time, so if you're interested I can tell you the origin myths, stories that arose to it. Originally known as Bear's Lodge, it became subsequently known as Devil's Tower, Bad God's Tower. This is problematic. The climbing on Devil's Tower is problematic for a number of these tribes who held this site as sacred. It had already been damaged by all these bolts, and there really was no support among tribal members for any further use and abuse of this site, abuse as they saw it. And just a sidebar to native religions. A lot of Native American religions are land-based or have a significant connection with the land. Another example would be Uluru in Australia, to give another example, a non-US example. It could be important for one of several reasons, historically where the gods live or where something else important has happened. And the idea is that the site has to be given time of its own, so that it is a living, breathing part of the world that needs protection and ministration. So land-based religions tend to be a touch counterintuitive if you're used to a Judeo-Christian model, but this is the example that we're looking at right now. So the National Park Service, in a move that was particularly sensitive and particularly aware of the competing activities and competing claims for use of this national park, of this monument, set up a body, a working group of key members, key groups who were would find this important. And there was a huge amount of toing and froing and discussion, and ultimately they came up with a compromise, which was June is a particularly sacred time for this for the land-based religions that honoured this sacred site, and this was a particularly popular month for climbing. And the compromise that was struck was that there would be, importantly, a voluntary restriction on climbing during the month of June. So voluntary closure to climbing during the month of June. And importantly here, we saw another case. There was a case brought to the Wyoming Federal Court by climbers. This case was brought in 1996. And I won't go into the specifics of the case. Basically, the climbers brought a number of claims, and they were told that they didn't have standing to bring most of them. But importantly, what was held here was that this was a voluntary ban. It was a voluntary closure, and therefore it was not a promotion of religion. This is particularly important because it would be unconstitutional under the First Amendment in the US, because it would violate the Establishment Clause. So importantly, it was held that this is merely an accommodation and not a promotion of religion. As the voluntary ban was maintained and held and holds to this day, climbing in the month of June in Devil's Tower has dropped by 85%. So to an extent, a success story. Taking those facts, we can apply it to the criteria that we use for legal pluralism. Two or more different governance traditions. We see here the federal system and the tribal systems, the tribal religions. The conflicting obligations. Well, on the one hand, quite clearly we have the climbers claiming a liberty to climb the tower at any time, arguably making the case why should your religious practices, which I do not share, prevent me from claiming this renowned site, one of the premier sites in the world? And on the other hand, the tribes, you have a duty not to claim this sacred site, at least during certain times, notably the month of June. And the argument here is one of an erga omnes duty not to claim. It's not an in rem property claim, but rather an erga omnes duty not to claim or otherwise disrespect or abuse the tower. Is there, in the final criterion, a sufficiently legitimate body to adjudicate? No, we have no legitimate institution to adjudicate on this case, but interestingly, when we look at the insight and the compromises struck through the working group, we can identify that consultation and negotiation and a little bit of prescience before entering into any decisions could arguably provide an alternative to adjudication, certainly to litigation.
Okay. So just take you back to the aims of this study. We wanted to argue first off that you can have a non-positivistic view of law and still accept the phenomenon of legal pluralism. And we arguably have shown this. We've taken moral objectivity seriously, but nonetheless emphasized the importance of conflicting beliefs about existing obligations. This renders, we argue, the idea of legal pluralism compatible with non-positivism. We also wanted to give you an account of legal pluralism that focused on what was morally important about it. And we've done this by looking in the main at political legitimacy. So when there is legal pluralism, there is some sort of political legitimacy crisis. And we've given you arguments to suggest that these moments in history are important in and of themselves because of the implications that they have for equality and autonomy. We also wanted to use this model to focus attention back onto ongoing institutional injustices. And we've done this today by focusing on particular social justice issues in relation to indigenous communities, particularly in the US, although as we mentioned before, we think this is scalable around the world. This is a general model. Okay, so thank you very much for listening, and we're happy to take any questions.
So we've got plenty of time for questions. There's a question there. I'm going to start with a couple of questions, if that's all right. And we've got plenty of time for others. So my first question is perhaps awfully simple-headed, so forgive me if it is. But the definition that you use for legal pluralism, correct me if I'm wrong, doesn't feature any claim about obligations being legal. So the initial claim is a claim of competing claims to governance, and then there are claims about moral obligations, etc., etc. So maybe you could just clear that up. The reason I ask it is, one is sort of intuitively, for a definition of legal pluralism, surely there have to be competing legal claims at play here rather than simply moral claims or political claims. But in the context of indigenous justice and indigenous jurisprudence, it seems to me that one of the crucial areas of contention is whether indigenous practices are recognised and afforded the status of law, rather than simply custom or moral practice, whatever it may be. So that's it. So maybe just clarify that.
Yeah. Shall I? So that's an excellent question, and in many ways it actually highlights the importance of taking a non-positivist approach, because a lot of legal theorists who have dealt with the problem of legal pluralism before have at some level been positivists, and so they assume that a legal order has to be at least a semi-closed off normative order that is premised upon certain things, like a Grundnorm that demarcates the legal from the non-legal. But non-positivists traditionally don't really care about that as much. So when I was writing my thesis on international law, I spent the best part of a year vexedly trying to pin down exactly what I meant by international law as opposed to anything else. And my supervisor said to me, but Alex, you don't care about that. Call it international schmore if you want to, because what matters surely is what's morally relevant about particular governance practices. And if you go back to the original literature on non-positivist legal theory, so stuff like Ronald Dawkins' work, he defines law in terms of certain values, so the importance of justifying state coercion. Now that's not a definition of law that any positivist would accept, because it is far more permeable around the edges. And I think one of the emancipatory values of this account is that it allows us to deal with indigenous governance practices without quibbling over, but where's the rule of recognition? Where are the law-applying institutions? That degree of flexibility helps because it cuts to what really matters, which is we've got people trying to govern themselves within a particular situation, a situation of dominance. And all of the problems that we would generally characterize as falling within rule of law concerns are active here. So, I mean, to somebody who was deeply skeptical of this as an account of legal pluralism, to a certain extent, at least I would be tempted to sort of shrug my shoulders and go, fine, but then we need to have a separate argument about why it's so important that it counts technically as law rather than law adjacent for these purposes. I don't know whether you want to add anything.
No, just, I mean, it's a particular post-colonial set of affairs that you do tend to have these competing governance traditions, is all of which one is arguably privileged, is invariably the one that we would recognise as being the dominating group.
And also, I mean, on most non-positivistic understandings of law, laws are just principles that arise from what the participants would tend to regard as legal practice. And so from the point of view of an indigenous community or First Nation, there's, as you point out, very often not a tight distinction between, say, religious and cultural practices and legal practices, because they tend to be bundled together within governance, at least in some instances. And so what really matters is, we say, the principles that govern those self-governance practices, and that's what the non-positivist would refer to as law. Now, if it doesn't fit the sort of Western notion of a modern municipal legal system.
Sure. Yeah. Okay, so Alex had a question.
Thank you. That was an interesting answer. I think that's the thing I like best. I think in this whole way of looking at things is exactly that sort of leading us away from expectations about what the law it should look like, and then just talking about what matters in terms of like actual people's lives and how affairs are handled. I like that. So let me get but. So I have like 3 levels of disagreement or skepticism.
I was like, he's being nice or grace.
3 levels of let's say skepticism. And the deepest level of skepticism, which we won't talk about, but I'll just flag it, is are there such things as moral obligations?
I'm not playing this game.
We're not going to get into that. But then maybe more interesting to talk about is, and I do mean this, because I sort of oscillate on that first one a little bit, but on the second one, yes, I think I do take this seriously. I really don't think legal obligations create moral obligations. And maybe you can convince me otherwise, but again, that might be too deep an issue to get into. So let me get to the third level of skepticism, which is the sociological one, which is where you say, very early on in the presentation, you say, one of the things you say is that there are these instances where people feel that they are under conflicting moral obligations as a result of the conflicting claims of 2 legal systems or normative claims coming from 2 systems. And that's the part where, like, I have empirical skepticism about that claim. Like, is that true? Do people actually feel that way? What leads you, if you could go to your first or second slide, actually, that would be. It's actually put up early on in the presentation in a way that I can't exactly remember. Maybe in the second or third slide, early on. Our data, that some people believe that more than one legal order places demands on them. Okay, so yeah, I understand that they might have demands. They're aware that the legal order places, there are two conflicting legal demands on them, maybe. But it seemed to me in the presentation that you were also saying that they experience this as two conflicting moral claims. And then in the second example that you have, right, where with the rock, I don't really. To me, it seemed like there were two conflicting claims, but the same people weren't subject to both of them. So, like, there are the people who want to climb the rock. They don't recognize any moral obligation, maybe, not to climb the rock. Then there are the people who don't want those people to climb the rock, and they say there's a moral duty not to climb the rock. So it's two audiences, or two groups of people, and so they're not experiencing that conflict. It seems like each one of them has their favorite claim or their favorite obligation that and then they for pragmatic reasons maybe come to some kind of compromise solution. But all the while, each group has its own respective sense of moral obligation, and so there isn't this point of empirically this point of conflict between the two. That's where I think there's more room to talk about that.
In the interest of time, I would perhaps urge you to choose one of the registers of critique.
Yeah, just the third. Just the third one. Just the third one.
All three. So that's the third.
Yeah. So I mean, that's a great question, and I suppose to a certain extent we have to say, well, mea culpa, but don't hold us too strongly to the wording of the slides, because I think there are going to be many different kinds of belief that people have about situations like this. Some of them will be a belief in the existence of conflicting obligations. Some of them will be a belief in one obligation and a belief that other people are saying that that's not the obligation you have. Similarly, when we talk about obligations, we're using it in the Hofeldian sense to sort of relate to, rights, liberties, as well as duties, no rights, powers, immunities. So the potential range of different obligation-related beliefs could be quite broad and quite complex. Now, the legal moral thing, it's not for a non-positivist that legal obligations create moral obligations. It's that they are moral obligations. Now, we're not saying that everybody involved in this kind of situation is deep down a non-positivist. That's the rational reconstruction element of the account. So we're saying that, at least in a preliminary sense, we can identify people out there in the world who have beliefs that something like this is going on, or that they are somehow involved in a situation where people are making claims of this kind.
Yeah.
Right. So that, and remember, this is very much the pre-theoretical stage. So there's a mess to be sorted out there, and so it's necessarily going to be quite hard to categorize. And so what we're trying to do is impose some order on it by reconstructing this mess of different beliefs, which may or may not be accurate, into a particular sort of framework in order to elucidate what's at stake morally.
Can I interject something that would be helpful to deal with problematic people like me? Is that if you had some body of empirical work to back up those sets of claims, it would be very helpful to just fend off these kinds of people. So psychological, like lab stuff, maybe survey data or something from these kinds of contexts, to just give someone some concrete thing to hang their hat on, because otherwise, it's my skepticism, spidey senses just go crazy, and I'm like, well, is that true? I don't know. Maybe that isn't true about how people feel. So I would just want to have some.
Yeah, we're looking into empirical.
Yeah.
We're looking into empirical options. It's just it takes time, and we're 26,000 apart. It's entertaining, cooperative.
I mean, there are instances where native jurists, if I can use that term, like James Henderson, right, would say, or has said, to power, your law says this, but this is not what our laws say in relation to the same. So, I mean, he at least, like on public record, identifies situations like this, and I accept that that's anecdotal, but we're not trying to diagnose a sociological pathology here. It's enough that this happens sometimes in some places, I think.
That book's coming out.
Yeah.
That book's due out next year. We're like, oh, it's not
Read
out
that
yet.
book. It's going to be a great
It's
book.
going to be a good book.
Scott has a question.
Thank you very much. That's very interesting. Just a couple of small comments and then a bigger problem. It seems to me the two examples you used are not conflicts of obligations. If you want to use the Hofeldian thing, one says we have a liberty right to climb the mountain, and the other says no, you have an obligation not to. And you have a dispute not between two competing obligations, but between a right and an obligation put in different circles. So I'm not sure that you're always talking about conflicting obligations here, unless you jump to another level. I wonder, in response to Alex's question about the moral objectivity, whether this isn't just a new form of colonialism. You start telling people this is what morality and law looks like, and this is the only way. Now that doesn't seem very pluralistic to me as an approach to understanding the world. The last thing is probably the most important though, which is that it seems to me that if you talked at the end about a political legitimacy crisis, and of course this is precisely what isn't happening here. The United States Supreme Court and the dominant legal system has no crisis with this whatsoever. There is that the crisis is for those who are trying to get their claims heard, but not for the dominant legal system. That's why you're still having these problems in the first place. You wouldn't have these problems if they did genuinely see it themselves as a conflict. And in fact, what follows from that is that to resolve the problem in the way that you're suggesting is to get rid of legal pluralism. In fact, you only have legal pluralism under the conditions that you described in the colonial setting. You don't really have it if you resolve it, because then you get rid of these problems. So,
do you want to or shall I try?
Yeah.
I'll make a start. Okay. So first point, we agree. They're not always conflicts of obligations. We're using obligations in the higher order sense to refer to. It's just Hofeld's phrase, jural relations and juridical instances, is a bit of a mouthful. And so sometimes it's more expedient to refer to obligations. So in the paper we go through and say, there are powers and immunities and so on. Yeah, we can add in a slide to point that out. We were just a little bit conscious of time, I think. So we agree with you completely on that first point. I'm not really sure how to respond to the allegation that this is just another form of colonialism, apart from to say that I at least would consider myself to be in the business of making truth claims. I'm certainly not coercing anybody or dominating them to the extent that I'm forcing them to accept what I'm saying. I'm not persuaded, which I think might be the underlying point, that in order to respect somebody's beliefs, we have to uncritically simply accept equal validity amongst all beliefs. This is a particular way of diagnosing a social justice problem. One of our hopes is that it's useful as a means for combating it by bringing some clarity. What tends to be the approach, at least of the American administration, is to obfuscate and point to the differences in cultural practices and then throw up their hands and say, well, this is so difficult to resolve, I think we'll just apply federal law anyway. By accurately pointing out that there is this kind of conflict going on, we hope to make it less easy to perpetuate domination through obfuscation, right?
I'm trying to think of an example where the crisis was for the dominant legal system, and the closest I'm coming up with is the situation caused by violence against women, particularly Native women in the US, and violence against women is a general problem, but specifically bad in terms of American Indian and Native Alaskan women. The rates, I think if I get my numbers correct, the rates are, you have a 1 in 3 chance of being raped or sexually assaulted if you're a native woman, which rises to 1 in 2 if you're Native Alaskan, which is unbelievable, 50-50 chance going out your door in the morning. So it was actually Amnesty International, their Mazes of Injustice report in 2006 pointed to this and actually cited the USA as a rights violator. They were like, you have to get this sorted. And for the first time, it pushed the violence against women issue onto the table, specifically in terms of Native women. And it resulted in quite feted legislation in the Violence Against Women Act of 2013, which came into force in 2015. In the interim, there was a very successful little pilot program that operated. Now, whether or not it would fit, I would have to give this more thought about whether or not this fit our circumstances of legal pluralism. But what was particularly interesting about this situation is that the USA proceeded on the logic, as it were, of we have to solve this problem, we have to plug this gap, and which they did incidentally by expanding the restriction under Oliphant to allow for tribal police to prosecute offenders of domestic and dating violence on the reservation. So if you're a non-Indian and you beat your Indian wife on the reservation, and tribal police could arrest you. Previously, they could take you to the edge of the res and dump you there, and that was about it. So it plugged this gap. Interestingly, the logic that the tribes were coming up with was, this is a recognition of tribal sovereignty, this is a recognition of the quality of tribal justice, this is a pushback against Oliphant and something that could be expanded upon legislatively in the future. So I think there's situations where the dominant system can have these crisis points. Just citing that by means of example, I haven't given any thought to whether or not that really fits within our circumstances that we outline.
Yeah, and there's another point here as well, because that uses legitimacy in a slightly different way. So when we're talking about political legitimacy, we mean moral legitimacy. So the unjustifiability of coercing in accordance with some decision, right, as a moral matter. Now, I agree with you that there's very often not a crisis of legitimacy in the social sense, but at least on the one side of that coin. But we're not really speaking to that. We're speaking to, so very often, a crisis of moral legitimacy might exist without anybody talking about it or being aware of it. So, for instance, the institution of slavery is a perfect example of this. People came out in favor of it for hundreds of years, and certainly I think we would both argue that that seriously undermined the legitimacy of all governments that were supporting it, even if nobody involved in those institutions realized that. So it's a claim about moral legitimacy, not a claim about social legitimacy.
Yes, sure. Yes, thank you. Professor, I note you are specializing in international law. So I want to ask a question regarding the international law, whether the legal pluralism exists in this arena. And I have read a book by the German philosopher Hegel in his legal philosophy, and he said in the international law, both the spirit of contract and the spirit of sovereignty exist. And so if a treaty or a contract is signed between two sovereign states, and this has moral obligations or legal obligations on the two countries. And while for the spirit of sovereignty, the countries should have the autonomy and discretion to decide their own affairs. So there is a clash of legal obligations or moral obligations in some conditions, as Hegel has mentioned. So I want to ask, what is your view on this point?
Okay.
Thank you.
Thanks. That's a great question. I'm going to avoid it as best I can. So I think it's logically possible that what we call legal pluralism could exist at the international level. However, insofar as it exists, insofar as there is international law as a single body of principles. It can't exist within that, because it would fall down at the first requirement, which is that there are two or more governance traditions. Now, international law by definition is supra-state, so it exists between states rather than on the part of conflicting domestic legal systems. Now, you tend to get references to legal pluralism at the international level, either in the context of, say, the European Union. And we actually are going to argue in the paper that the European Union is not an instance of legal pluralism. We don't think that there is a legitimacy crisis in the moral sense there, right?
Until the British arrive.
Until the British, there's just a crisis when the British arrive, right? Legitimacy or otherwise. The other circumstance where you find this is in the literature on the fragmentation of international law. Now, we take no position on this in the paper at all, as far as I'm aware. We're certainly not contemplating doing it, but as a sort of as a personal aside, I'm deeply skeptical of that argument, the idea that international law is fragmenting into different separate legal orders. I think there are powerful considerations of the international rule of law that should make us resistant to arguments of that kind. As to where Hegel comes in here, I'm not a Hegelian. I would always be a little reticent to take a Hegelian interpretation of international law, given Hegel's somewhat authoritarian views about the state. He would certainly want to endorse an almost eccentrically strong view of state sovereignty that many contemporary international lawyers would probably not sign up to, at least in the detail. Plenty of international lawyers are happy proclaiming generally upon the importance of state sovereignty, but when it comes down to actually applying treaty obligations and stuff like that, they tend to be a lot more flexible. So that's why I try to resist the Hegelian point of view. Thank you for that. No, that's why it's not in the paper. So we don't agree about it.
We don't agree on fragmentation.
I think we have had our fill of time. If there's any final pressing comment or...
I guess just to say thank you so much for such an excellent set of questions. Yeah, it was really useful.
Well, please join me in thanking Jen and Alex for a stimulating hour or so.
Thanks. Throwing spokes in the wheel.